Well, let's go ahead and get started and get into the topic. I'll talk some general things, and then we'll talk some Kansas-specific things. I think there's probably about 90 slides. I'll do my best to get through those and kind of cover the waterfront, so to speak, on this particular issue. A whole lot of things to talk about here. Water law is comprised of statutes and case law. The statutory law, both federal and state, of course you have at the federal level the Clean Water Act and the Safe Drinking Water Act. Those are going to be the two big ones at the federal level. And then we have state water law too, and that's different. Then we have regulations at the state level and a layering of administrative rules. We also have common law or judicial made law, and that's derived from the English law. And you can imagine that if our water law on the common law side of things is derived from England, that's going to be established in one way that may not necessarily fit as you get further west into the United States, because water is plentiful in England and not necessarily plentiful when you get west of basically central Kansas on a line drawn north and south through the country. And of course, regulatory law, you would have the EPA, and primarily the EPA and the U.S. Army Corps of Engineers would be the primary regulatory bodies that exist at the federal level. Now, water is both it is a unique natural resource. It's both a fugitive and migratory resource. Okay? It is not bought and sold typically. It's not possessed. And by being a fugitive and migratory resource, that means it's difficult to capture and it changes form. Okay? There are various water allocation systems. And again, I'm talking generally here for a while, and then we'll get down to specifics. So this is just kind of background information for you. And the riparian system, which predominates in the eastern third of the United States, basically, you could generally say east of the Mississippi River, but it also applies in places west, including Texas, which is interesting. But in the riparian system, which is the carryover from England, land ownership is a prerequisite to the right to use water that is below or adjacent to the land. So it's known as a bank right. Riparian. I'm a riparian owner. I own the land that is the bank to the stream. And I can withdraw water out of the stream for as much water as I want, as long as I don't diminish the quantity or change the quality of the water for a downstream riparian. That's the theory in general. And again, that still prevails in the eastern third of the United States. On that point, before I talk about prior appropriation, for my law students on Monday, I passed out a bunch of information to them that USDA has on its website, and it shows production levels by state of various agricultural commodities and livestock, because this afternoon's lecture is on Chapter 12, bankruptcy. So if you want a depressing topic, join me for class this afternoon. We'll go through bankruptcy. But what I wanted to show them was where farmers and ranchers get their income from. And the USDA breaks it down by crops, and you see all the various types of crops, including even the California type crops and fruits and produce and orchards and nuts and seeds. And then of course you have the what we would call the traditional row crop type operations. And I said, look at of course I asked the question, what is the number one ag producing state in the country in terms of dollar volume of ag commodities produced? And what would you say? California. Yeah, you guys got it right. California. They missed it. They said Iowa. I said, well, Iowa's number 2 and it's a distant second. And then I showed them cost of production. And if you look at cost of production and you look at total volume of ag products, Indiana and Kansas are about the same. Now, I'm from Indiana. My family farms in Indiana. We're 5th generation now. Actually, in the farm home that I grew up in, my great nephews are in my bedroom. So it's passed down. It's my brother's son's children. Well, I guess that's not 5th. What is that? I'm 2nd generation. My nephew is 3rd, so 4th generation. Okay, is where that's at, my great nephews. And I told him, I said, if you look at Indiana, where I'm from, you look at Kansas, The level of total production is about the same. Now, Indiana is a much smaller state geographically. And then you look at cost of production to produce about the same, higher in Kansas, less in Indiana. Why? Water. It's water. We don't have to irrigate anything. Water's a pain in the neck in Indiana. Get rid of this stuff. And none of them got that right either. So that was interesting to see them learn, oh, it does cost more to produce the same stuff in Kansas than it does in Indiana because of your diesel cost to run wells, your electricity costs, those types of things. Yeah. And I remember when I first started out in practice, a lead partner in the firm, and of course that firm was the #1 firm in the country for estate planning for farmers and ranchers. And the fellow that started that firm, the famous treatises are all named after him, and I'm the editor of those now. And he would always love it. He said, I just love it when Iowa has a drought. Because what's he thinking? He said, in Nebraska, we just irrigate. We can irrigate, Iowa burns up, crop prices go up, and that melts away that cost of that irrigation. So he said, I always love it when we read the reports that Iowa is having a drought. I've never forgot that, but it's related to water. It's related to water. The second system is the prior appropriation system, which Kansas has a form of the prior appropriation system. The first party in time to put water to a beneficial use has the first right to that water. Okay? So that's known as a senior appropriator. You have senior appropriators and junior appropriators. And often the prior appropriation system is coupled with a permit system. You have to have some type of permit that dates your appropriation. And Kansas has that. It's a governmental administrative system of water allocation. Now, Kansas used to be a riparian jurisdiction. I guess if I could give bonus points out today, when did Kansas switch? Anybody know the roughly? Can you get me? Pardon me? 49. Yeah, you're real close. 45. Yeah, 1945. You're real close on that. Okay, and that raised at the time a constitutional issue. If I get a chance, I'll come back to that. But if we go back to the riparian system, if you strictly applied the riparian doctrine, that's not conducive to economic development because I can't withdraw water for consumptive use because, as I said earlier, yeah, I have a right to withdraw water from a stream that flows past my property, but I can't change the quality or the quantity of that water. I can't diminish the flow for somebody that's downstream. So I can't use it for a consumptive use, which would diminish the quantity. So that's not very conducive to economic development. So over time, courts recognized that, and they softened the strict application of the doctrine, and they recognized natural and artificial uses. So you could withdraw as much water, the court said, as you wanted for natural uses, but not for artificial uses. And it became kind of unique how they defined and what became natural uses and artificial uses of that water. And it also recognized the concept of upstream and downstream riparians. One of the early cases on this was out of Illinois in 1842. And here, this was commerce at that time, a stream flowed through Merriweather's land. And he erected a steam mill and depended on the stream for water to run the mill, to turn that mill wheel. Evans buys land upstream from Merriweather and also built a steam mill. There was a drought in 1837 which decreased the amount of the water in the stream. Everything's fine when there's plenty of water for both of them to turn their mill wheel. But there was a drought in 1837, not enough water to support both steam mills, and so Evans thought it'd be a great idea. Now Evans is upstream from Merriweather. Evans builds a dam to divert the water to himself. And they end up in a battle over this. So who's got prior rights on this? Can he obstruct the stream? Now this is where we got the notion of natural and artificial uses. And the court said no. The Illinois Supreme Court said no, We've got the difference between artificial and natural uses. Natural uses are those necessary for survival. You can have as much water as a riparian that you need for survival. Artificial uses only increase comfort and prosperity. So an upper riparian can use all the water for natural uses, but not artificial uses until the lower riparian has satisfied all of their natural uses and their natural wants. So the obstruction of the stream was improper. So natural uses over time became domestic uses, water for the household purposes in the home, as well as watering livestock. So keeping people alive, keeping animals alive. That was a natural use of the water. Artificial uses, interestingly, not plants. Irrigation was an artificial use. It wasn't put in the same category of an animal, a beast, or a human. It's a living organism, but to irrigate that was deemed to be an artificial use. So you were limited. And that concept goes back almost 200 years. Manufacturing and municipal also were artificial uses in some states. So if you had competing artificial uses, so we've satisfied our natural wants and now there's not enough water to satisfy artificial uses of multiple users of water from that stream, what do? Well, the courts came up with a reasonable use rule. You know, when the courts say, well, has to be reasonable. Well, that's a whole lot of gray area. That's not black or white. That's a whole lot of gray. Reasonable depends on the circumstances. And that use also must not interfere with other riparians. So that indicated that a riparian's interest is in the use of the water, not in the natural state of the stream. But some restrictions on use are permissible. Now, here's an Iowa case, northwest Iowa, in 1897. And this shows you what commerce was like in 1897. This was big business. Knorr wanted to put a dam across the Floyd River so as to form a pond, and he's going to harvest ice and sell the ice. This is in the days before refrigeration, and this was a big deal. Gehlen used the waters of the stream for propelling the machinery of a flour mill. Again, we're back to that mill wheel. Both of them, for both of them, their use of the water was artificial. So how's the court going to say who has priority with respect to that water? And so the question, more narrowly focused, is what rights do riparian owners have to the use of the waters of a non-navigable stream for artificial purposes? And so this is where we see the court applying a rule of reasonability. The court said, well, in general, we're talking about equal rights between riparian owners. So we start with that proposition. But they said in 1897, the strict application of the riparian doctrine has to yield to the needs of modern society, ice harvesting and turning a mill wheel. Okay? So the issue is the reasonableness of the use. And so they said the detention of water for 2 or 3 days, get your pond filled, and then release it, that's okay. That's not an unreasonable use. But you just can't permanently impound that water. Okay, so that gives you an indication there of how the courts early on tried to balance the uses of competing water users. Then there's something known as littoral rights. This is the same thing as a riparian right, but the term is littoral when I own adjacent to a lake, not a stream that flows by, but a body of water. So this rule says a lakeshore owner can withdraw water from the lake if such withdrawal does not diminish the quantity or quality of the water in the lake. Okay? All right. Now, riparian rights pass without mention in a deed. So if you're in a riparian jurisdiction, you own land adjacent to a stream, the deed doesn't need to refer to that. That just happens. Okay. I own the land, I'm adjacent to the stream, I have the riparian rights if I buy that land. It doesn't have to be mentioned in the deed. However, they can be severed from the land and conveyed separately. Economic effects, holders will apply water until the marginal return equals marginal cost, likely to be zero. Non-riparians cannot acquire rights unless transferability is permitted. Now, without transferability, the riparian system is not economically efficient at all. You have to have transferability of those water rights. Now, the prior appropriation system is basically the western 2/3 of the United States. Prior appropriation in combination with some sort of a permit system, that's the western 2/3, basically west of the Mississippi. And that establishes rights to water based on when water is first put to a beneficial use. This is first in time, first in right. This is the rule that Kansas follows. You get a permit. My water right dates to such and such a time. I'm prior to somebody else. And in time of shortage, the senior holder can basically shut off the junior appropriator. So it's that priority system is important. But you have to put water to a beneficial use. Can't waste it. Now, there are some exceptions here. If I'm not using the water for conservation reasons, I didn't need to because maybe there was plenty of rainfall that year, you won't lose your right. And that's part of Kansas law too. But senior appropriators can shut out junior appropriators in the event of shortage. The system is typically administered through a permit system. And you have the Kansas Water Office. In the Division of Water Resources, you have the chief engineer that is the head of all of this. But beneficial use is the key to the prior appropriation system. Okay? And you have a right to divert and use water consumptively based on making a claim and putting water to a beneficial use. Non-beneficial uses are of no effect. You have to put the water to a beneficial use. And again, that depends on the facts and circumstances of each case as to whether a particular use is beneficial or whether it's a wasteful use. The famous case on this, perhaps the most famous case, is out in the Bend, Oregon area, beautiful part of the state of Oregon. I'm out there about every 2 years in some part of Oregon to speak. Maybe the next time I go out there, they'll be part of Idaho because that is huge out there. I was in Idaho 3 times last year. What a debate they've got going on about secession. But the Deschutes Water Company, a power plant located on the Deschutes River, built a terminal that used about 40 second feet of water per year to flush the debris out of its turbines in accordance with a notice of appropriation filed in 1905. And the trial court disallowed that practice and said that's wasteful. That's not putting water to a beneficial use. They said there's a different way that you can do that without affecting farmers in this whole area. Now, it's kind of funny when we look at this. This is a 1930 case. When you look at the numbers involved, 40 second feet of water. How much is that? We have some water specialists here. 40 second feet of water. How much? Can you help me out here?
Cubic feet per second, is that what they're referring to?
Pardon me?
Cubic feet per second?
Cubic feet.
So cubic feet per second is not quite 500 gallons per minute, so 500 times, would you say 20,000 gallons per minute, roughly?
Yeah. Would you say it's a lot?
Quite a bit.
Is that enough to flush out turbines of an electric company on the river?
Probably more than enough.
More than enough, yeah, okay. And then the court felt it was more than enough. That's why they pinned him back on this and thought that was a wasteful application of the water at the power plant. And the reason they said was they looked at the surrounding circumstances. They said the river is the sole source of water for irrigated land in the area, and that water could support the irrigation of 1,600 acres of land. So the company, they said, you need to devise ways and means to dispose of the debris without the use of additional water. So they pared back the amount of water to what the court felt would be a useful amount of water to flush those turbines out without impacting irrigators in the area. So that's an old case. It's 95 years ago, but you see the application there of the beneficial use doctrine. Now, the modern trend is to require a particular use to not only benefit the appropriator, but also be reasonable in light of present and future demands on a particular source. Now, this issue right here, present and future demands, some of you may have followed the issue between Texas and New Mexico and Colorado on water in the Rio Grande. Does anybody know what I'm talking about there? Those states entered into a water compact back in 1938. It was approved by Congress in 1939, and the Constitution says that the Congress must approve state water compacts. That's in the Constitution. And of course, in the 1930s, agriculture was different than it is now. The demands on the water in the Rio Grande were much different than they are now. And things had changed between the states, a lot more irrigation agriculture going on, and different, more uses for that water. And it was impacting the flows in the Rio Grande. So the states got together and they came up with a modified compact. And they got pushed back by the Supreme Court in 2018 and said, no, you can't just do this on your own. You've got to involve the federal government because the federal government has an interest here. There's a treaty with Mexico that involves water in the Rio Grande. There's also some tribal rights to that water. So the federal government has an interest which trips the Constitution. You've got to get this blessed by Congress. So the states kind of ignored that and went ahead and did their own deal. And last year, was back at the Supreme Court, and the Supreme Court said, look, you were here in 2018. We told you that Congress needed to be part of this, and that's what the Supreme Court said in 2024. States can't just do these deals on their own in terms of multi-state compacts because of the constitutional provision. But what they're after there is trying to figure out what is a reasonable use of the water in light of present and future demands. And that's why the states were trying to modify that compact. They said the demands on that water source had changed over the years. Well, that's true, but when there's a federal interest, then the federal government has to be involved too. Okay, and that has to be approved by the Congress. Okay, we'll skip the economic one. Go to the permit system. That is government control of water allocation. The state is deciding who uses water through the issuance of a permit. All right. And those state systems vary greatly in scope. They are based on statutory law. And this is just kind of summation of the various types of permit systems across the country in states that administer water rights by a permit. Some regulate only unused rights. Some will regulate groundwater rights. Surface water might not be subject to regulation. Some states will regulate collecting rainwater. The permit might be for a term of years, and it might terminate for non-use with some exceptions. Okay, Kansas has variations of just about all of that, or most of those in there. Okay. Now, again, there's some economic concerns with the permit system too. There was a constitutional issue raised when Kansas switched from a riparian to a prior appropriation / permit system back in the 40s. And some of the riparians there said, well, that's a constitutional taking of my property right. I didn't have to go to the state and get a permit and get your permission and be allocated a certain amount of water in accordance with my permit. And by imposing that now, you've taken some of my private property, which requires compensation under the Fifth Amendment. They largely lost that argument, but the state did move a deadline about 40 years in advance, 40 years forward, and said, you know, we could have something known as a vested riparian if you went to the state and made a claim that you were a vested riparian by the late 1980s. And so if you were an old, crusty riparian, you could go and have that secured by the late 80s. But that issue is long gone by now. So you have to follow state law for obtaining a water right, and priority stems from the date of filing. All right, and there you can see the economic issue that can be caused with a permit system. So they all have their benefits and their detriments, which raises a question. So I go to the state, I get a water right, I'm issued a permit. It says I can withdraw so much water every year, or for a period of time, whatever the water right or the life of the permit. So I have to have the state's permission to do that. What happens if I overpump that right? That's really kind of a big issue that's out there. Well, always monitor your raw water diversion meters. That allows you to know where you're at. It allows you to know where you are in terms of the amount of water pumped. Also, it allows you to know whether you could be at risk for receiving a penalty from the Division of Water Resources for violating the terms, conditions, and limitations of your water right during the year. Now, it's good to monitor that, because by the time you get a report that you're supposed to fill out and send back to the state, and I'll talk about that in a moment, it may be too late to correct things. So if you're acting proactively, you might find that maybe you've got some leakage someplace, maybe you're starting to get close to overpumping, or you can correct it before the state issues you a fine. So there might be some administrative actions you can take before year end to keep from getting fined, and that proactively lets the Division of Water Resources know of your situation. And sometimes the overpumping is not on purpose. Now, admittedly, sometimes it is, and I'll show you some of the things that have gone on and where some of the fines have been issued. And the fines, that system, they've really ramped up the fines. Division of Water Resources says they're not in the business of collecting fines, but the fines have gone up significantly than they have in the past, but they're concerned about the amount of water that's being used. So there's kind of two things there. Now, the water use reports are mailed out in January, and the water right holder completes the report. How many of you have completed a report? Okay. And you still get them in January? Yeah, okay. By the time you complete the report, if you got a problem, it's too late. That's why I'm saying if you're staying on top of monitoring your water usage and what your meters are saying, you can correct it before you got to fill out the report. And maybe they can take some proactive steps, or you can take some proactive steps to avoid a problem. Now, there is no level of overpumping that doesn't trigger a penalty if the violation lasts more than 24 hours. Okay? No level of overpumping that doesn't trigger a penalty if the violation lasts more than 24 hours. So you got 24 hours to correct it, which can lead, if I have multiple wells, I can kind of play a game with that if I want to. And I'll get to that in just a second. That's caused some problems. Now, beyond 24 hours, the fine is based on how long it took you to realize the water right was being overpumped and whether you received a notice of violation or were otherwise sanctioned during the previous calendar years. Okay. How many times have you been sanctioned in the past 5 years is going to be the big question. Just once, twice, 3 or more times, because they're going to categorize the level of penalty that can be imposed by how many violations there have been. 85% of the water rights that the Division of Water Resources deals with are for irrigation. Kind of makes sense. We would expect that to be pretty high, and it is. It's 85%. Now, when the Division of Water Resources writes new water appropriation rules and regs, it's primarily focused on the use of irrigation water. That's the mindset that they're in. When they're writing regs, writing rules, they're thinking water to be used for irrigation purposes. But statutorily, the law has to treat all water users equally. Irrigators, other types of water users, such as municipal, industrial, stock water. And it's the state's responsibility, or the Division of Water Resources' responsibility, to make sure that those other uses are not unfairly penalized. That's the tricky part for them. They're writing the rules basically for irrigators. That's what they have in mind. But state law requires that all types of water users be treated equally. That's the tough part from an administrative and regulatory standpoint. So what are the problems that give rise to issues with the Division of Water Resources on overpumping? What are the big issues? Well, we've seen these problems. Removing flow direction stickers from the water flow meter and turning the meter around backwards. You know, one I saw on that, you want to know what the water user's answer to the allegation was? Where's the sticker? What was the response? Think of a response. What would you say if you got a water right and the sticker's gone, the state finds the sticker's gone? Sticker is not supposed to be gone. Dog ate it? You're close. Cow licked it off. And then bumped the meter and turned it around. Was that a winner or not? And no, that didn't work. I mean, you got to give the guy a lollipop for that. That's pretty clever. But no, that did not work. That's what he argued. He still got fined. Somebody else turned the meters around on weekends. Why weekends? Yeah, nobody inspects. These are state workers. They're done at 5 p.m. on Friday. We got free reign for a couple of days here until they show up. Well, not necessarily so, as he found out. Somebody checked it on a Saturday. Oops. But that was the thought process. Yeah. You know, they got to show up on Monday morning and come up with the 5 things they did the past week. So, rest of you'll figure that out in a minute. Okay. I saw that last week and I thought, shoot, 5 things, I can do that by 7 a.m. on Monday morning, the 5 things that I've already done. Somebody took a meter apart and modified the impellers and changing internal gears so that the meter didn't fully account for all the water flowing through it. That's really naughty. Don't do that. That got a big penalty. Okay. Related to this, on the crop insurance, well, kind of related to this, on the crop insurance side of things, don't do what a farmer in southwest Kansas did, who's now in prison. Are you familiar with the crop insurance fraud case down there? Yeah, the National Weather Service will give you gauges to measure rainfall, because if you're going to make a crop insurance claim, what's important to know, what they want to know is how much rainfall did you get, what did others in the area do? Okay. He had a tendency to, I guess it was just more convenient to park equipment over the top of the rain gauge and drill holes in the bottom of the rain gauge. And that got discovered. Now, this was not the first time he'd ever done that. I remember when I was in law school, we studied some of the early cases where this fellow was in trouble with the law back in the 1980s, 70s and 80s. Finally caught up to him. So when you're an octogenarian, you get to go to federal prison now. What a great way to go. Don't defraud that. Don't mess with rain gauges. On crop insurance. And shoot, if you want to defraud a federal farm program, pick something other than the crop insurance program. You could actually make money with the crop insurance program. It actually pays. Defraud other programs. Let me rephrase that for the archive that's being made. That's tongue-in-cheek. Don't defraud programs, but if you're going to pick one, pick something other than the crop. If you're going to do it, do something other than the crop insurance program. That one is watched pretty closely, and it actually is pretty financially good for a lot of farmers. Well, what are the Department of Water Resources procedures? Well, the chief engineer issues a notice of noncompliance on first noted violation. That's basically a warning ticket. You're going to get a warning. Okay. But look at the problem here. This is how you can kind of game the system, and they've caught on to this now. Some water users have multiple water rights and wells, and they play a chess game. That's what I call it. They play this chess game, and they'll say, well, we'll overpump one water right 1 year. We'll get a warning ticket on that one. Oh, we'll clean that one up. And then they go overpump a different water right the next year, and in hopes of avoiding the sanctions, because that's a different water right. And so if you have multiple of these, you can rack up multiple warning tickets and you still haven't been fined yet, and you just overpumped your right. That was happening 20 years ago. The Division of Water Resources kind of caught on to that. The initial fine was only $250, and I can guarantee you, farmers know the math. They say, $250? Put more water on those crops, I can make that up in the market pretty easy. We'll just take a fine. So you overpump the right, get a $250 fine. Now the rules changed. In 2017, no more warning tickets, largely. Fines imposed at a much higher amount. Civil penalties capped at $10,000. Basically, when you get a fine, you're starting at $1,000, not $250, and they're capped at $10,000. So the fines are more substantial. And it became apparent that water users based on this, when the fines went way up, look what happens here. Now you've got another problem. So water users with lower producing wells were being penalized more highly than those with high producing wells. How so? Well, what was happening in Kansas was that the high producer well could pump a lot in 24 hours and just get a notice of non-compliance because you got that 24-hour window. So there's a lot of water that they can pump in 24 hours, correct the violation with 24 hours, but all it is a warning ticket. Well, for example, a public water supplier with a lower authorized rate, because the permit's going to give you your rate on there, would take days to pump the same amount, which now you're beyond 24 hours and you're going to get a big fine. So does everybody see the problem there? Division of Water Resources realized, oh, okay, that's not working out the way that we intended that. We're going to have to modify that. So they have layered the penalties. So there's classes of penalties, and then there is a division within the class of penalty, or a category, and then a classification in the category. And I'll go through that here in just a second. Now in the regs, and here's where you can find it in the administrative regs, 5-14-12, enforcement is against the owner of the water right. Now you want to think in lease situations, any penalty that's going to be levied and any enforcement action that's going to be done is not against the tenant. It's going to come back to the owner of that water right. And it attaches to the right and transfers with the right to any subsequent holder. Now, what this is talking about here is because we've got a 5-year look-back period where the state's going to look to see if there's any penalty associated with that right. So you could end up buying a water right that's had a penalty imposed on it in the previous 5 years, and that's now in your category. So if you have a first violation, that's actually a second violation, if there's been one prior in the previous 5 years. That's how they do this now. So there's this 5-year look back. And what the reg says is any violation may be subject to penalties assessed against the water right for a violation that occurred during the 5 calendar years preceding the calendar year in which the most recent violation occurred. So they're going to look back, the state's going to look back 5 years. Are there any previous violations in that 5-year window associated with that water right? That will tell the state in which category you're in, and the category that you're in is going to set the penalty. All right, so here's the structure. Penalty, or category 2, means you've had one penalty in the prior 5 years. Now this is the second penalty. You're in a category 2, and we're going to start the fines at a certain level. I didn't put the numeric amount of fines in there, but I have the statute with me in case anybody asks. I can pull it out of my bag. Basically, we're going to start at $1,000 and we're going to go up. Category 3 means 2 prior penalties in the previous 5 years. 3 or more is category 4. Then there is a severity classification within each penalty category. Now, some violations might be severe. Some violations might be intentional. Some violations may not be. And maybe you had a mechanical malfunction. Maybe you had something that's malfunctioning and it's leaking and you didn't know about it. Well, that severity level comes down. It's still a penalty, but the severity is less and the penalty is less. Do you understand how that works? That's how the state is doing that. So you want to make sure you know your authorized quantities to avoid penalties. Research your water rights. Okay? And the state will help you figure out, if you don't know, the state will help you figure out what your water right is and what the authorized level of pumping is and how long the right is good for. Are there leaks in your distribution system? That's another issue that's out there that can create problems. Also, compare your water use with others in your area to see if you're out of bounds. Are you low? Are you high? Are you kind of within what everybody else in your area is? And you say, well, how do I do that? Well, the Division of Water Resources publishes annual statistics regarding water loss for every public water supplier in Kansas. So you want to kind of check that out and see where you're at. Are you in the norm, or are you high, or are you low? If you're high, then you might have a problem in your system. Okay. All right, that's Kansas specific. Any questions on that? Yes?
I might make just a real quick point of clarification, more of a comment, that you were absolutely right. Under 24 hours, there is no penalty.
Right.
However, if you've done it previously in that 5 years, there is a penalty, even if you're under 24 hours twice.
Yeah, that gets you to category 2. That's good clarification. Yeah, if you've already, what he's saying, if you couldn't hear, yeah, you got a 24-hour grace period, but if there's already been a penalty, then you don't get that grace period. That's correct. Yeah. Okay.